Appeals, First Appellate District of Ohio, with the Honorable Jennifer Benson presiding, is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have two cases set to be argued this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case on the docket this morning is C-24-0419, State of Ohio versus Nicholas Flannery.
Ron Springman, representing the state. We're ready to proceed. On behalf of Nicholas Flannery, we're ready to proceed. Thank you, Ron.
Thank you. And the second case on the docket this morning is C-24-0277, Eastlawn Properties versus State Automobile Insurance Company.
Zach Gottesman for appellant, we're ready to proceed.
Matt Curry, co-counsel, Zach, for state.
Thank you very much. If the parties on the first case would like to come forward. Good morning, Mr. Springman. Would you like to reserve time for rebuttal?
Your Honor, thank you. I'll reserve 3 minutes for rebuttal.
All right, you may proceed when you're ready.
Your Honor, the issue in this case is very straightforward and set forth by defense counsel on page 33 of the hearing of May 23rd, 2024, and that is whether or not the state is required to produce exculpatory evidence at the grand jury proceeding. And as we know, a grand jury proceeding, that's the accusatory stage of the criminal justice process. It's not an adjudicatory stage where we present all sorts of evidence and have cross-examination and iron out the differences between expert opinions.
Do we have to decide that issue on this appeal? I mean, isn't this appeal really an appeal of whether the defense gets to see the grand jury transcripts?
Your Honor, if I believe they want to see the grand jury transcripts and file a motion to dismiss the indictment on the ground that the state did not submit exculpatory evidence before the grand jury.
So we have to go ahead and decide the main issue that they haven't filed a motion to dismiss yet on?
I would think you would. I thought they did file a motion to dismiss. I know originally they did not when I was reading the record, and then I know there was a representation in the record that they were going to file a motion to dismiss. I thought they did, if I'm mistaken.
But that's not up on appeal, right?
I thought it was. I mean, what we are here on is the issue of whether or not, yes, they want disclosure of the grand jury transcripts to see whether or not the state presented exculpatory evidence to the grand jury.
Right. And the purpose is for filing a motion to dismiss?
That's what their indication is in the record, and I thought that there was a representation that they were going to file that motion to dismiss made before the trial court judge. And so I assumed that that motion to dismiss was filed because there was some references made in the record to that.
Wasn't that motion held in abeyance pending this proceeding?
Yes, I guess everything was held in abeyance, pending this proceeding. So the narrow issue is whether or not there can be an in-camera inspection of the grand jury testimony or whether or not the grand jury testimony can be disclosed. If it's that it can be disclosed, then defense counsel has to establish a particularized need for that grand jury testimony, and that brings us right back to whether or not.
Let me present a
exculpatory
scenario
evidence.
to you, and then you explain to me from your perspective if it's right or wrong. So my understanding of what's been described by the defense as the particularized need is to prove the absence of this evidence at the grand jury stage. And let's just play this forward. Let's say that they do want to go forward with their motion to dismiss. What's to prevent the state on this record from saying, defense, you can't prevail on your motion to dismiss because as a factual matter, you can't prove that the evidence was not presented to the grand jury. Isn't that the particularized need they're trying to establish, that the evidence as a factual matter was not presented to the grand jury? And aren't they trying to eliminate the ability of the state to oppose that motion on that factual basis?
Yeah, I suppose, Your Honor, I think we're conflating some issues here, and it's somewhat now a little bit difficult to narrow down what, in my reading of the transcript over the weekend, I am under the assumption that what defense counsel wants to do is they're trying to establish a particularized need on the basis that the state did not present exculpatory evidence to the grand jury.
And that could be a factual question, or it could be a legal question.
It's a legal
right?
question because statutorily, the state is not obligated to present exculpatory evidence to a grand jury. The United States Supreme Court in Williams said the state is not obligated to present substantial exculpatory
Well, let me
evidence to the
phrase
grand
this
jury.
another way, another hypothetical way. Let's say hypothetically, the state did present the exculpatory evidence. And let's say hypothetically, the grand jury transcript showed that. What then?
If it showed it, then I guess the defense would want to compare that evidence, if it were one of the physicians from Cincinnati Children's, they would want an in-camera inspection so the trial court can review that physician's testimony and determine whether or not the trial testimony of that physician is consistent with the testimony presented by that physician at the grand jury.
It seems to me, again, approaching this hypothetically, because we don't exactly know what the grand jury was
Yeah, I
at
don't
this
know.
stage. Approaching this hypothetically, it seems to me that there are two ways in which the state could respond to this motion to dismiss. Number one being the legal one, that there is no legal obligation.
No, there's not.
Number two being the factual one. We did or we didn't present this information. And that the particularized need being described is the factual one. We'd like to cut off the factual argument. That's what the defense is saying. We'd like to know one way or the other, and cut off the factual argument. And then we'll just be left to debate one way or the other the legal argument. What's your response to that?
If the defense wants to know whether or not exculpatory evidence was presented to the grand jury, I would go back to the legal argument, because exculpatory evidence, it doesn't matter. The state is not obligated to present exculpatory matter before the grand jury. It simply is not. Not statutorily obligated. The United States Supreme Court says the state's not obligated to present exculpatory evidence. The Ohio Supreme Court has said the state is not obligated to present exculpatory evidence. So I think the issue in the law ends right there. I think the whole premise of asking for exculpatory evidence from grand jury transcripts just
So the
It's a
only
way
way
it
we
stops.
the only way we decide this case, in your view, is that we have to get to the ultimate issue of whether the state is obligated to provide exculpatory evidence.
and the state clearly is not.
So, and I guess I kind of looked at it differently, because the motion to dismiss is not being appealed. I mean, there's not been an order on that, right? So that's not up here. The only issue is whether the defense can see these grand jury in order to file a motion, I guess. That's my understanding.
Well, Your Honor, on page 33 of the May 23rd hearing, it's very clear to me that defense counsel wants to view the grand jury testimony to see if exculpatory evidence was presented, and is alleging that it's a due process violation for the state not to have
Right.
presented that exculpatory evidence.
But they're wanting to look at it so they can file a motion to dismiss, right? Isn't that, I'm just trying to
Yes, I
understand
guess they want to
where
look
we
at
are.
it, maybe to file a motion to dismiss.
Okay,
Let's say that's, but they're not entitled to look at it, is our view, because if that's the basis that they're.
well, it sounds
after.
like they have an argument which has not been decided by the lower court. You're asking us to decide. They have an argument to get around all the cases that you're citing that say that the prosecution is not required to present exculpatory. They want to argue that, right? And so the lower court hasn't decided that issue yet, has it?
Sure seems to me that the lower court, from reading the record, has decided that issue. Because when you look at the entry, and I'll give you the exact words that I did have memorized, but I don't, but after reviewing the grand jury transcripts in camera, the trial court ordered that it be disclosed to defense counsel because it tends to support the defendant's arguments.
So, given that's where you are with the trial court, if we were to assume that the exculpatory evidence was not presented at all, and the trial court has already reviewed it, would the state be in a position, if it wanted to, for the purpose of the determination of the substantive motion to dismiss, to just stipulate that it was not presented?
I suppose we could stipulate that it wasn't presented, but, I get back to one problem, and that is the law does not impose any duty on the state to present exculpatory evidence.
Well, I think the point is, though, at that point in the process, that issue would be ripe. It's not necessarily ripe now, where the motion to dismiss has not been ruled on.
Well, when the trial court grants it grants the in-camera review of the grand jury testimony.
So the trial court already knows, one way or another, whether or not the state presented any exculpatory evidence whatsoever. The
Yes.
state already knows one way or another. And for the
Yes.
purpose of the determination of the motion, if the state were to lose, the state would appeal.
Oh, yeah, absolutely, yes. If that's the view, yes, we would appeal, because again, we do not think that exculpatory evidence is required, or we're obligated to present that at a grand jury proceeding. I mean, the case law is just so crystal clear on it, and, I look, just one example, I was looking at the expert report of Dr. Scheller, and Dr. Scheller, goes through a timeline of events in the birth, so it's an emergency C-section. We don't know whether or not forceps were used. We do not know whether a vacuum was needed to extract this baby out, but there was an emergency C-section. There was a couple of visits that were, not a whole lot happened. And then all of a sudden, about a few days later in this timeline, I think it was in August, they noticed that the baby's head was very large in size and might have suffered a possible seizure. Then on September 7th of 2023, the notes indicate that the baby suffered bilateral mixed density subdural
Well, Counsel, I think
hemorrhages.
there's some reason to debate the science here.
Yes, you know
But-
why?
But isn't that a function of the trial court? And
Thank you.
And wouldn't that be a reason for the trial court to consider this in the first instance, which has not yet happened?
Yeah, I mean, the trial court viewed that, I just trying to grasp my mind around the trial court viewing the grand jury testimony in camera and making a ruling that it should be disclosed to defense counsel because it tends to support their arguments.
And
which
is that a
suggests-
factual or a legal determination? Which one? How should we read that?
I believe it has to be a legal determination, because if the trial court is going to disclose the grand jury testimony on the legal basis that the state did not submit exculpatory evidence to the grand jury, then that's an error as a matter of law.
Can I ask you a question? So, clearly the defense wants to challenge this case law, okay?
Yes.
Okay. So do you have an issue with the trial court simply doing it in camera? And
That
saying-
occurred, yes.
It occurred, and it's saying, okay, this information was not turned over. Go ahead, I'm not going to let the defense see it. I'm not going to let the defense see the grand jury testimony. I've looked at it, and I have made the one determination that the information that they are talking about was not disclosed to the grand jury. And then, okay, parties, go ahead and litigate the issue.
Okay.
I mean, do you have a problem with that happening?
Well, I really can't have a problem with that happening, because then we have an opportunity to, as a matter of law, to reach the issue that we're concerned
Right,
with.
so you
But-
don't have a problem with the trial court just doing an in-camera review and finding out if exculpatory information was or was not disclosed to the grand jury?
Your Honor, I do not. The trouble I'm having is that the trial court did do an in-camera review of the grand jury testimony and said it tends to support the defendant's case, meaning they made these arguments that the state should have put on exculpatory evidence. That was the whole
Right, but
basis
you don't want the
in
defense to
camera.
see the grand jury testimony. I'm just saying, could there be a way for this issue to be litigated without turning the grand jury testimony over to the defense?
If there is a way, I don't know why we would really have a problem with it. I guess.
The way I just described.
The way you just described, I don't know why I would. I mean,
Or a
why the state
stipulation.
would. You
Either
know,
one.
You mean stipulate that there was no exculpatory evidence presented to the grand jury, and then we are back up here?
It seems like those are two ways to do it, and that protects the state's, I understand the state's interest in keeping the grand jury secret. That seems like the overriding concern.
Well, yes, of course it is, because, yeah, the
I mean,
law
like,
requires.
but at this point, the trial court hasn't said the fact that that wasn't given over is in fact the reason to grant a motion to dismiss.
No,
The state would appeal anyway.
Right. Those magical words, I guess, were not uttered. I guess we're drawing an inference when the defense is asking for exculpatory, or is alleging that the state knew and did not present this exculpatory evidence to the grand jury. Then the trial court views the grand jury testimony in camera and agrees with the defense. To me, that's kind of an inference that the judge is saying, okay, there is no exculpatory evidence that was presented to the grand jury. I don't know. Maybe I shouldn't draw those inferences, and maybe it needs to be clarified in the court below.
I agree with the inference. I just question whether, I mean, that's where I'm stuck here. Does the grand jury testimony then have to be turned over to the defense in order for the defense to be able to file a motion to dismiss?
Well, the defense has to show a particularized need for the grand jury testimony, and their particularized need is that it's exculpatory evidence. That's what they're arguing. So that's why I think the issue is right for this court to review.
And you're out of time, if you'd like to
Okay,
reserve.
I appreciate it. Thank you.
Thank you very much.
Good morning, Your Honors. Steve Kilburn on behalf of Nicholas Flannery. Your Honor, Your Honors, the trial court clearly did not abuse its discretion in ordering that the state provide me, defense counsel, with a copy of the grand jury transcript. And before we address that ultimate issue, I want to be very clear why we are here today. And that is because the government glorifies form over substance. Since when did the rights of the innocent take a backseat to the state's desire to uphold tradition and essentially procedural tradition? Since when did a defendant's constitutional rights take a back seat to the state's desire to uphold a procedural tradition.
Can you answer, though, the question that I was asking the state? Why does the defense, in order to file a motion to dismiss in this case, need to see the grand jury testimony if the judge can simply do an in-camera and determine whether this information was presented or not? Like, why does the defense also need to see the grand jury testimony?
Well, I want to be clear, I don't need a copy of the transcript to file a motion to dismiss. I already filed the motion to dismiss. The judge ruled explicitly that my motion to dismiss tended to support my arguments to that effect. And it seems to me the court is inclined to grant the motion to dismiss, but wants me to have an opportunity to supplement my motion with the grand jury transcript. And, you know, I want to be very clear that the legal standard is...
Can you identify the particularized need?
Sure.
As you see it? What is that?
Absolutely. Well, number one, in order to obtain a copy of the grand jury transcript, two things must take place. The legal standard is, one, the ends of justice require it, and two, the particularized need outweighs the government's interest, okay? And so the ends of justice requirement, it's beautiful language. I don't know what that means other than, is it fair? And the question I would submit to the court is it fair to who? The government or the innocent?
Let's assume that we agree with you on that
Sure.
piece. What is the actual particularized need? What do you need this for?
So this, right, and so the reason I need this is because there are two reasons that we've demonstrated. Number one, Mr. Flannery's due process rights were violated because the state had actual knowledge of substantial exculpatory evidence it did not present to the grand jury. Now,
So it's to prove the negative, right? It's to prove that it didn't show up in the grand jury.
we know the exculpatory evidence the state had actual knowledge of was not shown to the grand jurors. It would have never indicted in this matter were that the case. And we also know this, the government just came up here and said, well, sure, I suppose we could stipulate that no exculpatory evidence was
So
presented.
would a stipulation get you where you need to be?
Judge, no. For the second reason we've demonstrated a particularized need, and that is because precisely the United States Supreme Court recognizes that refreshing a witness's recollection, testing a witness's credibility, and impeaching a witness establish a particularized need. This is also followed by Ohio courts through Dennis v. United States. And you know, the big thing here.
So who is the witness? Can you help us just drill
Sure.
specifically down into this? So who is the witness that you want to impeach with the grand jury testimony?
So the interesting thing about this is the government wants to maintain the secrecy of the transcript, but the prosecutors told me there was a single witness. It was the detective with the Blue Ash Police Department. So they've already told me who it was. And so, you know, the only way the government could have succeeded in obtaining a true bill in this case, that witness had to tell the grand juror something that led the grand jury to indict. And so we know none of the exculpatory evidence was presented. They had and by the way, at the juvenile court had a case concerning identical allegations, identical alleged conduct. The government could not even show probable cause that this happened. They knew that, still proceeded with an indictment.
So
2
are
weeks
you,
ago, that case was dismissed for insufficient evidence.
so are you saying that somehow you'd get the testimony of the police officer and then impeach the testimony of the police officer?
Precisely because my concern is that there was something that he told the grand jurors. If he told the grand jurors that this child was diagnosed with an injury, that is flat out wrong. There has been no diagnosis of an injury in this case whatsoever at all, in
But
all the
isn't
discovery.
this speculative? I mean, there's a lot of case law that you're up against here. The headwinds are hard for you in suggesting he could have said this, he could have said that. We'd like to see what he said in order to shut down that line of testimony at trial. The case law just in Ohio doesn't support that way of thinking in terms of accessing grand jury testimony.
Well, I mean, the case.
Is there something more that you have in terms of a particularized need to cross-examine?
Well, it states two things. I know where the court's going with this. I mean, the case law says to allow disclosure based on mere speculation of impeachable material would render all grand jury testimony subject to disclosure. But it's not speculative. We know that he said something that was false in order to get the grand jury.
How do we know that?
Because the government could not prove a preponderance standard that this happened. The government could not prove clear and convincing evidence standard that this happened. We know that. And we know that we are entitled to the grand jury transcript by virtue of testing a witness's credibility. There is
At trial.
no, to establish a particularized need. We can obtain the grand jury transcript by refreshing a witness's recollection, testing a witness's credibility, and impeaching a witness. And so, as long as we articulate.
It seems like all of that just typically happens at trial, though. Even when grand jury testimony is disclosed, the impeachment doesn't come like at the motion to dismiss phase. That's what you're saying, right? It's like somehow, how would it even work? You would.
Well, because again, this is not speculation. The officer testified to the grand jurors that there was a determination that my client abused his son. And we know that's not true. We know that's not true because he was never diagnosed with an injury.
So now you're
We know
arguing that there was false testimony presented to the grand jury instead of just, what I thought your argument was, is the failure to provide exculpatory information for the grand jury.
So I'm arguing both, Your Honor. What I'm suggesting is there are two reasons we have demonstrated a particularized need. One being that due process was violated by virtue of not introducing exculpatory evidence that the state knew about. The second reason, you don't even have to agree with that conclusion to understand that we believe we know the officer made up facts in order to get the grand jury to indict Mr. Flannery. We know that.
So on the exculpatory evidence piece, do you agree with the state that this court has to decide this ultimate issue, which is basically the issue in your motion to dismiss?
No, I do not. And I believe that the trial court is in the best position to use its discretion and to do what it did, which is order the state turn this over to me. And, I think clearly the trial court did not abuse its discretion in making that decision. But again, I don't think this court has to necessarily rule on that issue. And I would also like to address the fact that the case law the state relies upon are two cases primarily. One of the United States Supreme Court, the State v. Williams case, United States v. Williams. That case dealt with a defendant who tried to argue his due process rights were violated because the government did not introduce at grand jury self-serving testimony. These were documents generated by himself, okay? Also, the court in its reasoning stated, well, if we basically required the government to introduce exculpatory evidence, we would transform the grand jury in its historical role as an accusatory body to an adjudicatory body. Well, that's the quintessential feature of a grand jury is to vote. It even says that in the Ohio criminal rules. I mean, so the purpose and function of a grand jury is to adjudicate. That's precisely why it exists. And so I disagree with the reasoning, but also the state court the trial court in this case recognizes that states can grant greater rights to defendants, right? The Constitution is a limitation on government power. States can grant more protection to defendants, and I think that the trial court recognizes that. And so that's exactly what the trial court did here, is say, look, I agree with you. this exculpatory evidence should have been turned over. They knew about it. Wow. And she outlines a laundry list of things that they knew about. She agreed with me. They knew about this.
So your position is that the trial court did in fact resolve the motion to dismiss?
It has not yet. It's pending. The motion to dismiss is pending, and the judge is permitting me to review
So when you say the trial court agreed with you on what?
Well, I can read the language, but it states here, the order says, it is probable that the failure to disclose testimony will deprive Mr. Flannery of a fair adjudication of the allegations. For example, defendant has shown the following evidence was admitted in juvenile court proceedings where the state of Ohio, represented by different prosecutors from the same Hamilton County Prosecutor's Office, and thus the state had imputed knowledge of the following substantial exculpatory evidence. The child had a traumatic birth. The child had a diagnosis of chronic subdural hematomas since birth. The child had excessive head growth and excessive fluid buildup. The child's...
So do you think that language, the probability language, and then the tends to support language that comes later in the order, do you think that those amount to a determination of the motion to dismiss and that we should therefore reach that issue? Or that is just a signaling of where the trial court's thinking was at the time?
Well,
and we should not reach the issue? Which one?
Well, I think that clearly establishes the standard that we need to show under State v. Greer, which is that a particularized need is demonstrated when the circumstances reveal a probability that failure to provide the grand jury transcript will deny the defendant of a fair trial, and that is precisely what the trial court determined.
I'm just going back to my question.
Sure.
If the trial judge did an in-camera review
Which she has.
and determined that the state did not present that exculpatory information like you are alleging,
Yes.
why do you have to see the grand jury testimony? Why can't you just make your argument
Well,
on the motion to dismiss?
because the trial court agrees with me that exculpatory evidence they had actual knowledge of
Okay?
should have been right, and
So why do you have to see the grand jury testimony then? You've proven that fact, that information was not disclosed to the grand jury. Why do you need to see the grand jury testimony then?
Because I want to also, again, because there are two reasons, not only that reason, but the fact that I want the grand jury transcript to buttress that argument to dismiss because there were falsifications that were.
But that's different. So your motion to dismiss, I thought, was based on the failure to provide exculpatory information to the grand jury.
It is.
Now you're arguing that the person who testified, the officer, gave false information.
Correct. and
Isn't
there's-
that a different thing?
It is, but there's no reason I can't supplement my motion to dismiss using another strong argument, right?
But I thought the judge found a particularized need due to the exculpatory evidence.
Indeed.
Okay.
And so I think that the trial court just wants me to flesh out the argument, and she knows that I'm in a better position to do that if I can actually see the grand jury transcript.
Okay.
So that's, to answer your question, I think that's.
It's
what the
really
trial
for
court-
your other argument on the false testimony.
Well, it's for both, I would submit to the court.
Okay.
It's for both reasons.
And your time has expired if you'd like to wrap up.
Thank you, Your Honor. Do I have, it's expired entirely?
You can take another 30 seconds to wrap up.
Thank you, Your Honor. So I think, again, state courts are in a position to grant, to protect rights, grant additional safeguards. The Ohio Constitution can offer defendants, the innocent, which Mr. Flannery is, can offer him greater protections, and the trial court understands that. The trial court believes that this exculpatory evidence should have been presented. She is in the best position to determine that there is a particularized need that has been articulated. She is in the best position to know that the state has no interest whatsoever. Any particularized need that we show would necessarily, it logically follows, would necessarily overcome the state's need, which is none, which I've, argued. So the trial court did not abuse its discretion. We're asking that this court uphold that decision.
Thank you.
Thank you, Your Honor.
this court does not rule on the ultimate issue, then I guess the grand jury testimony, the concern that the state would have is going to be disclosed. And then the defense would file a motion to dismiss based on the disclosed grand jury testimony. And we have a problem with that because it's very clear that the defense, in its motion, raised one issue, and that is the particularized need to see the grand jury testimony was based on the fact the state didn't present any exculpatory evidence. We're not obligated to do that. It's an accusatory body. It's not an adjudicatory body, and the law is all over the place on that, both statutory, Ohio Supreme Court, U.S. Supreme Court, we can go on and on about that. But I know you didn't want to get into the science, but that's a problem. That's why the grand jury is an accusatory body. Right in the doctor's report, he talked about bilateral mixed density subdural hemorrhages. That is a telltale sign for child abuse. It just is. I mean, ask any med student that's taken step 1 or step 2. Every question comes on the test. Anybody that's going to be board certified in neurology or pediatrics or obstetrics is going to get that question. And yeah, you have to know the entire clinical picture, but that's all for trial. That's why the state does not have to present exculpatory evidence to a grand jury, and that's why I was illustrating the science behind this.
Can you briefly address the additional argument that's been raised today that there's a particularized need for the grand jury transcript because there was allegedly false testimony presented by the singular witness?
There is no demonstrable evidence that any false testimony was submitted to the grand jury. That argument was not raised in the court below, and there simply is none. Well, I don't know what basis in this record that whoever testified before the grand jury lied. I mean, that's just a baseless claim right now. And again, I find it hard to believe that that occurred looking at the reports of the defense expert and looking at the injuries of the child. Telltale signs that are going to show that there was child abuse, that there was ATH and shaken baby syndrome, SBS.
I know I asked this already. I just want to make sure I understand your answer. You don't have, or do you have an issue with the trial court under these circumstances doing an in-camera review?
It already did.
I know, but if we had a future case like this, would you say if the defense was making this argument that the judge could say, hey, that the judge properly did an in-camera review, or do you take issue with even the in-camera review?
I don't take issue with the in-camera review
Okay.
at this point. That's not before us. I think that's the role of the trial court, is when there is a request to review grand jury testimony, usually that's the process. The trial
Okay.
court does an in-camera review, and if there's any impeachment material or, then in fairness, the defense gets to use that. But the basis that the state's required to submit exculpatory evidence to a jury, I'm just trying to show the science where we go down. We're going down to the issues of trial. You need the whole clinical presentation, and just the defense expert alone and viewing those injuries, those are telltale signs of child abuse. That doesn't mean there is. The whole clinical picture needs to be flushed out, and that occurs at trial, not at grand jury. But thanks.
Thank you for your argument. Thank you both for your arguments this morning. We will take the case under submission and issue a timely written decision. The second case on our docket this morning is C-240277, East Lawn Properties versus State Auto. Good morning. Would you like to reserve time for rebuttal?
I would. I'd like to reserve 5 minutes, please.
All right.
May it please the court, counsel, I'm Zach Gottesman. I'm here for East Lawn Properties, the appellant. This is an appeal flowing from the trial court's granting of a motion to dismiss one claim and then granting summary judgment on all of the other plaintiff's claims. So the standard of review for you this morning is de novo. The trial court made the determination on the motion to dismiss with a reasoned decision that explained the basis for the court's decision. the motion for some summary judgment was granted without explanation. So why the trial court made its decision, we're left to wonder. However, based on the record, and it's a dense record with a lot of depositions and a lot of exhibits, we have to start at the beginning. So
Can I just make sure that we're understanding what you're arguing? The full policy limits were paid in this case.
They were.
What you're arguing about is that they didn't pay above the policy limits.
no. Well, there is an argument that they owe money over and above the policy limit.
Like 200 and some $1,000.
Yes.
Okay,
But there's a second argument,
okay.
and that is, although they paid the policy limit, they are not absolved from their bad faith claim handling that occurred during the adjustment period
Right.
of the claim.
So all the factual disputes you think really go to the survival of the bad faith claim?
They do.
What about,
Which implicates the breach of contract claim, because their breach of contract claim is their duty to execute, pay the claim based on a reasonable justification with reasonable investigation and pay it timely. Those are inherent in the good faith fulfillment of their duties under the policy. Those also would, if they failed those duties, that would also support bad faith.
it seems like the factual disputes are all about the exchanges of information and the back and forth, and you think that amounts somehow to the bad faith claim?
It does. It does. There's some nuance in reading this policy that was missed on me when it was first presented to me. And it's under the lost payment provisions. It's on page 25 of the policy, on the right-hand side of the policy. In that particular portion of the contract, State Auto details that four options. It says we're going to pay for loss that the insured sustains in one of four ways. They'll either pay the value of lost or damaged property, they'll pay the cost of repairing or replacing the lost or damaged property, that's number two. And number three, take all or any part of the property in an agreed or appraised price, that doesn't apply. And then four, and now it's not to pay, but it's simply the active verb, repair, rebuild, or replace property with other property of like kind. And this is subject to paragraph D1E, which talks about the increased cost of repair due to compliance. So 2 and 4, under their duty to pay, are very similar. But 4 doesn't speak about paying for the cost of repair. It says that they will repair. They will act as the general. The record is clear. State Auto never specified whether it was proceeding under number 2 or number 4. Number 4 talks about increased cost of construction are excluded from the cost payable. That's the paragraph D1E. So this record is thoroughly permeated with emails where Jeff Maxwell is talking about the increased cost of construction due to compliance with municipal ordinances. And he sends the contractor and the insured on these goose chases to come up with evidence.
Well, counsel, I understand on this record that their explanation for that is that they were trying to categorize this $215,000 or whatever it was in additional cost. And they were trying to figure out what Norwood was actually requiring and how they were supposed to put this money into different buckets. Can you point me to something in the record that would show a dispute of fact about their purpose in asking for this additional information?
Their purpose for asking for the information is different, I'd submit. They can request that, but they shouldn't condition payment on it. Their duty to pay is under paragraph 2, or item 2, under their lost payment provisions.
And were they, help me understand that too. So were they holding up all payments while they were asking for additional documentation, or were they just holding up payments on the additional code amount?
So the payments came out incrementally. There was an initial payment to the fire department and a $200,000 payment on the initial estimate. Then there was, and obviously this project by its nature will require a certain amount of time to go by. But it starts in November of 19, November 6th. Jason Mateen from Paul Davis sends a spreadsheet to Jeff Maxwell. In that spreadsheet, he outlines what he refers to as supplemental expenses. It's about $230,000. Jeff Maxwell responds to that with, for review and discussion, a revised spreadsheet that comes in at $216,000. The precise number is what it is, but it's November 18th. So in that interim period, some evaluative process went on. And when he sends that back to the contractor, the only reasonable interpretation by the contractor at that point is, I'm authorized to do this amount of work.
So why do you think that? Well, it doesn't seem like an explicit acceptance of an amount. It seems like a back and forth that's contingent on some formal acceptance in the future.
I think the course of dealing between Paul Davis and State Auto, prior to this particular loss and this particular insurance claim, they had an established working relationship. The back and forth, and it's critical to understand that email from Mateen to Maxwell, the insured was not copied. My client wasn't copied on that email. When Maxwell responded to Mateen, the insured was again not included in that exchange. So
The insured was contracting with that general, right?
Islam did contract with Paul Davis, but then Paul Davis was dealing directly with Jason Maxwell, the adjuster.
But are you trying to
Jeff
argue,
Maxwell, excuse me.
are you trying to argue that Mr. Davis was led to believe that the company would pay, or that the insurance company would pay over and above the policy limits?
So Mr. Davis isn't a person in the case. I think you mean Jason Mateen. He was the guy, the construction manager for Paul Davis. Paul Davis is the name of the company.
Paul Davis,
Excuse me.
Matthew, I'm sorry, the person who was emailing
Right,
the insurance company was led to believe that the insurance company was going to pay above and beyond the policy limits?
Well, so Jason Mateen wouldn't necessarily know what the policy limits were, and he wouldn't know how much has been paid. He's a contractor
Okay.
doing work in the field. So
Your
when,
client knew what the policy limits were.
again, he did, but he didn't know how much had been paid, and he didn't know what limits there were.
Why not?
Well, so the testimony is there was a glitch when the deck page was issued, and there were coverages not on the deck page, coverages buried in the policy that applied.
But they had the policy, right? Even if it wasn't in the deck pages, the policy is the language of the contract.
Yes, no doubt.
Are you just saying that somehow that number 4 takes the limits kind of off the table?
It doesn't. What I'm saying, and obviously I didn't explain that well, Judge Nestor, what I'm saying is State Auto proceeded under the second option for lost payment. The fourth option is the one that references increased cost of the construction being excluded. They did it under lost payment provision number 2, which has no reference to increased cost of construction. Yet all of the emails back and forth reference the code compliance and increased cost of construction, which applies to 4, but not 2, which is what they proceeded under. So it's like
But it seems like 2, if you knew the ultimate policy limits as a consumer of insurance, you would think, I am only entitled to the limits.
Correct. You are stuck with the limits you bought, And you're a carrier, there's case law that says they have a duty to keep you apprised of how much has been spent and what your limits are. And that didn't occur here. The evidence is clear. Jeff Maxwell, the adjuster, didn't keep him apprised of what limits applied and how close to exhaustion those limits he was. And the reason it's a big problem is because there's the November 6th email that Mathine sends to State Auto and says, these are the supplemental items that should be included in this repair job. On November 18th, Maxwell responds with his own spreadsheet that has all the same items, but at a minimally reduced cost, $216,000. It's appellant's position, at the very least, if that's not a contract, it creates a question of fact. What would a reasonable mind believe?
So they
when-
led him to believe,
Yes.
you're arguing that they were led to believe that the company would pay above the policy limits.
Would pay that, and not necessarily would pay it,
Well, it is above the policy.
it is, but they would pay that amount. I mean,
Okay.
what other message could the carrier be sending?
But is that a reasonable belief to have, though? That goes back to Judge Nestor's
By
question.
the contractor? I think it is
Well,
reasonable for the contractor to
But like-
believe that.
But why does the contractor's belief matter? The contractor is not the contracting party here.
Well, the contractor was dealing exclusively with State Auto.
Well, shouldn't the owner have been inserting himself
He
into
didn't
that?
know those communications were happening. He
Well,
wasn't included.
I mean, shouldn't that owner be monitoring what their GC is doing in
And-
terms of construction?
And I think the evidence is pretty clear that all the emails that Sean Scallon is the principal for Islam, this guy was more organized and more involved than I've ever seen, than most insureds would be expected to be. He had all his emails in chronological order, and he watched this claim and its evolution, its adjustment very closely. I mean, he's heavily involved in these emails. But when the adjuster and the construction manager start to interact without him, how is he to know that? There's no way he could know that.
Counsel, you're out of time if you'd like to reserve 5 minutes.
Thank you.
Thank you.
May it please the court. Your Honors, Mr. Goetzman, I think we're putting the whole cart before the horse in multiple ways with this appeal. I think the first question that everybody needs to answer in this one is, do we even get to this point? Can they even maintain this cause of action? Policy has a 2-year contractual limitations period.
Well, that doesn't apply to the foot dragging claim, does it?
I would submit that it applies to all of them because none of the claims would exist but for the existence of the insurance contract.
Well,
And the contract-
is that true of the bad faith?
I believe so, it is, Your Honor.
There's clear case law out of this court and others that a contractual limitations period doesn't apply to a foot dragging claim because that's a separate tort, not a contract claim.
Well, Your Honor,
How do you get around that?
Yes, Your Honor. I think 2 reasons. First of all, I think that I believe the case law you are referring to concerns the 2 different types of bad faith and whether breach of contract is a condition precedent to this. I don't think it specifically says that you cannot shorten a tort limitations period via a contract. So I think it's distinguishable on that point. And the second thing that I would have to say is regarding bad faith claims in general, traditionally there are the 2 types. Breach of contract is a condition precedent for one. Breach of contract is not a condition precedent for the second one. However, over the course of the past decade, and particularly in the past 5 years or so, I think the tide on that is shifting. And so I think it is kind of an open question of law. But to your point, even if we want to presume that the contractual limitations period does not apply to the bad faith claim or the foot dragging claim, as you said, okay, but that still takes care of the vast majority of claims here. And then if you want to focus specifically on the bad faith, you have to look for a reasonable basis. was there a reasonable basis here? Is there undisputed evidence of record that there was a reasonable basis? And I think the basic timeline shows that. The claim was filed. Shortly thereafter, $350,000 was paid. Upon substantial completion, another $160,000 was paid. And to your Honor's point, it was about finding buckets, putting different things in different buckets. There's $22,000 left in building coverage that wasn't paid. And that's what this whole argument is
But
about.
why is Maxwell sending this email, which seems to indicate that they're willing to pay more money?
Are you referring to the back and forth?
Yeah, the back and forth email with
Yeah.
mathing.
So I think you have to look at it in the context of the adjustment of an insurance claim.
Okay.
So Paul Davis, as the contractor who you may or may not be familiar with, I know they've been involved in several appeals for interest in conduct, but they will say, this is how much we think all of this work is going to cost. Here's our estimate. The insurance company looks at that and says, well, this amount for this looks okay, this amount for this looks high, this amount for this is way too high. And then they adjust the amount that they would be willing to pay. But, and here's the important but part, that does not concern coverage. It's if there is coverage, then this is the.
Oh, so they don't even think about the limits at that stage?
Correct,
Okay.
100%. And,
And can I stop you there?
yes, Your Honor.
Does the insured get the benefit of that negotiation on their behalf, even if coverage is ultimately denied? Do you understand the nature of my question?
I do not. Can you rephrase
Okay,
that, please?
so let's say that there's some adjustment where a contractor purports to charge $150,000 for a repair, and there's some back and forth, and they get the price down to $125,000. But it turns out there's no coverage for that. But the price has been brought down to $125,000. So now the insured only has to pay $125,000 instead of $150,000.
I understand your question. I don't think I can answer that. I don't think any insurance company could answer that. If there's no coverage for it, that's just a matter between the contractor and the insured.
All right, so then it goes back to the insured to kind of deal with the
Sure,
contractor.
and
on
I'm
their
sure
end.
the insured would have a great argument of saying, well, why would you only charge him X and you want to charge me Y? But
And it's my understanding in the context of this negotiation or adjustment, that this spreadsheet was created by State Auto. Is that correct?
that's not correct. It was created by Paul Davis. But I don't want to confuse things, right? So Paul Davis prepares an estimate, whether you want to call it an estimate, spreadsheet, what have you, and sends that over to State Auto. State Auto then looks at it and makes the adjustments, and whether you want to call that an estimate or a spreadsheet, what have you. But it was initiated by Paul Davis and then sent to State Auto for their review, and State Auto looks at it, makes some adjustments, sends it back and says, let's discuss this.
All right, and why would the insured, why would Eastlawn not be a part of that conversation?
Because Paul Davis, as its agent, was doing these things and sending it to State Auto,
How is Paul Davis its agent?
because it's the general contractor for the project.
What,
And if you look at the contract between Paul Davis and Eastlawn, it specifically says, we are the general contractor for your project. You agree to pay any monies. However, we will try to work with your insurance company, et cetera.
all right, so the agency agreement that you believe exists is the contract between Eastlawn and Paul Davis.
Yes, but I think we're kind of getting on a sidetrack that isn't necessarily essential to this appeal.
Well, I don't view that as a sidetrack.
Yes, Your Honor.
That's why I asked the question.
Okay.
Because they've alleged as part of their foot dragging claim that they weren't included in the communication. That's why I asked the question.
I understand, Your Honor. What I would say in response to that is, I think the undisputed evidence shows that there was no foot dragging as a matter of law that the trial judge answered. As I said, $360,000, and I have on page 7 of my brief a very short outline of all the payments that were made. But a huge, over half was paid upfront based on ACV.
But weren't they asking for some sort of like letter from the municipality in order to provide a certain amount of money that was not even necessary?
So then this goes to the buckets question.
Right?
And so if you look at what happened, Paul Davis submits all of this, and the vast majority of it is for code upgrades.
Right,
And so
but
the
you don't need a
adjuster-
letter for code upgrades, do you?
Well, you need to, a code upgrade by definition is work that a governmental entity is requiring you to perform.
So you need evidence of that, is what you're saying?
Yes.
Okay.
And in this case, what happened was that Paul Davis submitted this estimate, the vast majority of which was identified as code upgrade. And so the adjuster, trying to find more coverage or as much coverage as possible, is going back to Paul Davis and says, essentially, are you sure this is really all code upgrade? Can you give me evidence of what Norwood is requiring or not requiring?
It doesn't say because you only have $10,000 in that bucket, right?
The policy does say that, yes. The
Yeah,
policy that
but
was
no,
provided-
but the contractor is not notified that there's only $10,000 available for code upgrade.
I don't know the answer to that question.
Okay,
I don't know. The insured was provided the policy 2 days after the fire. The insured knows the contents of the policy. The policy is very clear. You have 5.
but the insured is not included in these emails, right? It's just with the contractor.
The insured has to approve any and all work that is done. State Auto cannot approve any work on this.
Understood.
It's explicit in the Paul Davis.
I'm just trying to understand, the contractor provides all of these estimates that you're saying is way above the $10,000 limit on the code upgrades, right? And so your insurance adjuster is trying to figure out, okay, how much is this really as code upgrades? And I guess my question was, why wouldn't, at that point, the contractor be advised, like, hey, there's a limit here of $10,000 for code upgrades?
Sure, well, until, I think 2 things on that. One, if it's code upgrade, you have no choice. You have to do it. It's legally required. There's no ifs, ands, or buts about it. I think the second thing is the limits are what the limits are. And so if you have to do it, it's immaterial what the limits are. If you have to, if Norwood is requiring you to spend $70,000, it doesn't matter if you have 0 insurance coverage, 70,000 insurance coverage, 5,000 insurance coverage, what have you.
Okay.
But it seems like it's dissatisfying that the insurance company, at the very least, it's dissatisfying that the insurance company said, hey, by the way, didn't say, by the way, we're having this debate about a couple $100,000, but the limit is $10,000.
Well, so I would disagree with that because the whole purpose of those discussions is an attempt to find additional monies for the insured.
Well,
So State
how is
Auto-
that true if there's an ultimate limit?
Sure, so State Auto could have taken the Paul Davis estimate at face value, paid $10,000 and been done with it, and then leave $50,000, $60,000, $70,000 on the table that it didn't end up paying out. So it was to the insured's benefit to find this, because if it's classified as code upgrade, you get $10,000 and that's it. If it can be classified under the building coverage, then those monies could be paid to the building coverage. And then if the building coverage is exhausted, then an additional $25,000 in debris removal ends up being available. And so that's why it was very important to figure out what classifications these various repairs fell under. And that's why it took so long, because State Auto kept saying, we need information. You keep saying this is code upgrade. Are you sure this is code upgrade?
But then Maxwell he received numerous emails asking if the insurance company was going to cover the $215,000 from the general contractor, and never responded to these emails.
Well, I think if you look at the context of all of the emails going back and forth, beginning in November and continuing all the way up through September. There's additional information being provided to help classify those things. So, starting in November, 2 months later, when substantial completion certificate is issued, State Auto makes another payment. And then at that point, there's only $22,000 left in building coverage. And so for the next 3 or 4 months, the State Auto Adjuster is trying to figure out if any of the things that Paul Davis has identified as code upgrade can be put in the building bucket to pay out some more money. And that's what those correspondence from January to July do, and then additional money's paid out in July. And then there's a few $1,000s left. And so there's additional communications. And then by September, State Auto has enough information for them to be able to say, okay, we can throw 30,000 or whatever the exact number is into the building coverage so we can make these additional payments. And then by September,
That would be true of requests coming from State Auto to East Lawn. So, give us more to explain these additional costs so we can properly categorize them. But how is that true of just ignoring emails and being non-responsive to requests from Paul Davis's representatives as to what's going on?
when you say that may be true, what's the?
The
I don't understand
the
what-
attempt to properly categorize. So requests from State Auto to East Lawn could be motivated, and the record might show are motivated by attempts to properly categorize. But how would ignoring emails be motivated by an attempt to properly categorize?
I understand. And I would be speculating because I wasn't there. I don't know. But I think the short answer to the question is not responding to an email in and of itself is not bad faith. If no new information is being provided, which it wasn't for significant periods of time, what would the ultimate purpose in responding to that email be? It would be a non-substantive response. And so I think if you look at the actual substantive communications in this one, it really shows the process that State Auto had to go through. And at times, unfortunately, it was like pulling teeth. You can lead a horse to water, but you can't make them drink. I am, from State Auto's adjuster's perspective, I am trying, nudge, to see if this is under building coverage and not code upgrade coverage. And it just took a lot of.
Can I ask a quick question? So the building coverage was the 515,000?
Yes, Your Honor.
So then the debris removal, the 25,000 was ultimately paid for that? Was, what was put in that bucket, was that just debris removal or was that other stuff?
Yes, it's just debris. So the way that the coverage works is there is 515 in building coverage.
Right.
If and when that 515 max is hit, then to the extent anything within that 515 was for debris removal, it can shift over to the additional coverage.
Oh, okay. So
So-
debris removal, if you don't hit the 515, would just be under the 515?
Yes.
But then they would take it out and move it elsewhere once you, okay.
Yes.
Got you.
Yes.
Thanks.
And you're at your time, but you can wrap up.
Okay. The other thing I was going to say, I said initially there were two ways we're putting the cart before the horse. The second way concerns the lost payment provisions. The lost payment provisions do not affirmatively provide coverage. They just explain how the insurance company will pay the coverage that's delineated beforehand in Section A of the policy, property coverages. That explicitly says we will pay you for building. We exclude code upgrades. However, there's a $10,000 give back for code upgrades, and there's also a 25 building limit or debris removal limit if the building limit is hit. The insurance company did pay the policy max on this, and the insured ended up in a very good position. He bought this 1950s original building, and now he has a brand-new building as a result of all this. Thank you, Your Honor.
Thank you.
There's a few points I'd like to address here in this rebuttal opportunity. There's some glaring facts here, and this was a summary judgment decision and a motion to dismiss. My client ended up with a lien filed against his property. From January to September, while we were still in the adjustment phase, there was a lien filed against the property by the contractor. That should give rise to a question whether this claim was being properly adjusted or it qualifies as a foot-dragging bad faith claim. There was a 9-month period during which State Auto was requesting additional information. Additional information, nothing new was ever provided. They had what they had at the beginning of the 9-month period and when it was over, and they paid the claim with no new information. Yet during that...
Is that claim barred by the 2-year contractual limitations period?
No, for the first district decision you referenced when my opposing counsel stood up at the beginning. Also, under the hound shell claim case, it's our position that that 2-year limitation was waived because they had already agreed to pay the claim and they were in the process of paying it, which at that point would give the insured reason to believe that a lawsuit would not need to be filed. So to go back, excuse me, does the filing of a lien during this adjustment period and this delayed payment by State Auto, does that give rise to a potential foot-dragging bad faith claim? We have 2 experts in this case. One, Tom Bruns, who was identified as plaintiff's expert, who says it is bad faith, claim handling. And then the defendant also has an expert who says this is fine, nothing to see here. That should, I'd make clear, there's a question of fact here that's not to be resolved on summary judgment. The lost payment provisions that I'm referring to are on page 25, where it sets forth the 4 of the policy, the 4 methods by which payment for a claim will be made. The increased cost of construction due to code upgrade is on the next page, and it's limited in application to lost payment provision number 4. That's on page 26. So all of this discussion about buckets is predicated on a misunderstanding that that provision on page 26 applies to the lost payment provision number 2, which it doesn't. So their duty was to pay. They delayed payment. East Lawn suffered damages as a result. Damages in the form of attorney's fees, damages in the form of a lien interest filed against the property that was an event of default under the mortgage. The law is clear, and that is payment of limits of liability do not, by themselves, eliminate liability for bad faith claiming. So, unless there's questions, that's all I have on behalf of the appellant.
Thank you.
Thank you very much.
Thank you both for your argument this morning. We'll take the matter under submission and issue a timely decision. Enjoy the rest of your afternoon. The court is in recess.
All rise.